If I said that my panel was my favorite panel, this is one of the conversations I'm most excited about today. In just a minute, we'll get started. But for those of you who are here, I'm delighted to introduce Senator Robert Rodriguez, who was a prime sponsor of the Colorado Privacy Act, or CPA, not to be confused with the CCPA, or California's Privacy Act. So what I'm hoping we will hear about today in just a minute is a little bit of the story behind an actual privacy transparency law, and the rationale for why such a thing is enacted, and a little bit more information on what state legislators are thinking when they put in place actual transparency requirements. So maybe we get like another 2 minutes and we'll get started?
Sure. Just for the record, I am not an attorney. I only play one at the Capitol. I've been overwhelmed by this, so hopefully this will be a little bit of a downplay for you guys and dumb it down, and I could just tell you some more dirt and gossip of the legislative process. So it's good dessert time.
I should also point out how grateful I am that Senator Rodriguez made time for this during a very busy election cycle. So big gratitude on that front.
I've only taken a couple ballots, so if anybody needs their ballots dropped off, I am available to drop off. I was asked to go check out the student center to see if people were dropping off their votes. So.
Vote, make sure you vote. All right, so I think let's get started, and people can trickle in if need be. So again, it's my absolute joy to host Senator Robert Rodriguez. We'll again do a similar format of a keynote presentation first, followed by some discussion with me, followed by an opportunity for you all to ask questions and get answers.
So yeah, thank you all. It's an honor to be here. Thank you, Professor, for having me, and you all for being here. I got here a little later in the day. My intention was to show up and listen to the whole day's presentation, but as I got up this morning at 6, a little bit of snow and a lot of accidents, so I didn't want to ruin your presentation by getting in an accident and not being here to provide this to you. So I'm here now, and I came safely up, so thanks for having me. But I'm not a lawyer. Mostly, I've been in the Senate for 4 years. I came in 2018, started in 2019. Mostly worked in criminal justice, reform, small family business, work in the mental health and substance abuse field, but also did a lot of work in my couple years with consumer protections. My first year I came into the legislature, I worked on a pretty contentious bill that was there before I got there, which was the remote notary bill, which was before its time with COVID. It was something that they were trying to expand on. And it took me 2 years to pass just because of some of the arguments. But one of the big arguments was fighting with the trust companies and the deed companies was because they're recording the notarial act. What are they doing with that information? They're recording it. Are they selling it? You have access to the documents. One of the trick questions was the definition of sale. Which was a big issue that I didn't realize how much it was. And a little history about me, my wife is a privacy person, has done it, and I got into that with her, and I learned about, well, there's a lot of different ways of what sell means, and it's trading, and we thought it was for money. Well, there's a lot of other definitions. So that bill got done, and because of that, I decided to dabble into consumer data privacy. So this was in 2019, we started working on it, and we were going to introduce that bill. And I built a coalition. The people that worked on the remote notary bill with me were my House sponsors, which was one was Republican, one was a Democrat. I'm a Democrat for the record. I advocated for a Republican in the Senate to work on with me who had done some previous children's privacy stuff in the past. Believe it or not, there's a little bit of a privacy caucus in the legislature. The discovery I've had, and I've worked with other states and talked to other people even after we passed this bill, is privacy is very bipartisan. It's not a monolithic thing for people. The nuanced arguments for it are, but it was a good coalition to build. The first time I had a meeting with them, we sat down in a room and said, what do we want our bill to be? And I was, I'm probably more of a opt-in / right of action person, which I knew having a bipartisan bill I couldn't get done, but that's what I wanted. And I went in with my colleagues, and my Republican colleagues are like, I believe we should have an opt-in on everything. I don't want these people with their refrigerators in my house. And I was like, I love you guys. This is great. I was surprised, and we started working on a bill. So at the time, this was early 2020, and we started looking at policy, and California had just passed their bill. And we started, well, we started talking with lobbyists, we're going to do it. And the discussion got to be, please don't do California. Because at the time, California was a ballot initiative, and it was a kerfuffle of mess of people having to change it and regulate it. Some of the lobbyists were probably saying, you should do Nevada's. So I went out and looked at Nevada's, and it's like, well, Nevada excludes all the carriers and the providers. And I was like, well, of course you want me to do that bill. So I was like, no, we didn't do that bill. So we did a little research, and we came up with Washington's version, which never had been passed, but it was probably one of the most balanced and thought out bills that we had. So we modeled it after Washington privacy bill. We worked on it for 8 months. We took that bill, went a little stronger. Like I said, my wife and me were the first starters of drafting it, and my wife works in healthcare privacy. And the fights were going to be, well, this is untested, there's no proof, there's no way to do this, we can't do. So we modeled a lot of our first draft on HIPAA wording, which they didn't like that either, but just that's for the end of the story. But so we did the bill, and we were going to introduce it. I think it was going to get introduced in the legislature in 2020 on like March 15th. It was going to get right across the desk. Opt-in, full-blood knowledge, no right of action with the AG enforcement. And I could talk about that in question and answers if you'd like to. But so we were getting ready to do it, and that was the day that they shut down the legislature in the state for COVID. So we didn't get our bill read across. They pulled it off. We came back after COVID, and everything was shut down and everything was emergency. So the priority was not to do this bill. So we didn't introduce that bill in 2020. So we moved on, and we committed to work on it again for the next year, which we did. The next year we met with a lot of business leaders, and we did a lot of crafting, and we worked with a TechNet and a lot of tech companies who build conglomerates together that worked with us. And we worked with Consumer Reports, ACLU, some people from California. A lot of people were dabbling in it, but probably the biggest advocates was the business community, the chambers, and the TechNets of the world, which after our bill, we have a TechNet in this region. So if anybody's looking for work after that, we started that. Nobody can say Democrats don't create jobs. But so that bill got introduced, and we worked through the process. And a lot of the process was trying to build a balanced bill. As an advocate for opt-in, I believe that is good policy and a private right of action, but also looking at GDPR, and as somebody who is geeky enough that reads the privacy statements and the statements that come in the bill, I even now that our bill's passed and California's passed, I don't know how many of you actually read the privacy, accept cookies, accept tracking, which I read them too, and it's kind of sad, and I actually think those are dark patterns, which we could take it as like, yeah, accept all, or go into this multi-thing that's going to tell you how, if you check this box, we're going to enhance your experience, right? But so, we tried to be balanced with the business community, always knowing going in, my goal has always been the end user as a consumer. We fought very hard. My colleagues fought very hard. We got this bill out of the Senate unanimously 35-0, bipartisanly. Some of the mistakes, I did some amendments that I probably shouldn't have done. But, as you go through a process, you don't learn everything. I could talk about, if you ask questions and answers after, regrets that I didn't do in the bill or mistakes I made that I had to honor. One of them was probably the GLBA exclusion. I probably went a little too far on that, but because I made that commitment, I had to stick to it. But it's hard to get these bills done with the amount of force, because you have a few legislators, a couple advocates, which is probably Consumer Reports and stuff, but you're going against the whole business industry, which they all believe in this stuff. But when you dig into the amount of data and the amount of stuff that they collect on you, and the amount of, and the fights I had, whether it was the LexisNexuses of deleting the data, or the biggest pride I have in this bill is that we have a global privacy switch, which is the most uniformity thing in the nation, which was exciting. And for us, it was a very exciting thing to do in the bill. But, we worked on a lot of collaboration with stakeholders. My intro to the bill, which I thought I'd pull up to read to you when I had to go and present it, which was, I thought, would convince everybody I was excited about this bill. Maybe it sold it, maybe it didn't. But, I'm just going to read through my intro when I did this bill. He's like, there's no overreaching policy rule at the federal level that applies universally to US resident data. So the states are having to pass their own product for consumers to protect consumers. This is exactly what this bill is about, the protection of consumers and affording them rights around the collection, use, and disclosure of their data. Every week, privacy is a major theme that is in headlines of major news stories. Facebook, Cambridge Analytica, April 2021, Facebook, 267 million profiles listed for sale on the dark web for $600 a word. April 27, 2020, Nintendo, 160,000 player accounts hacked. Often, others such as Expedia, Pfizer, FireEye, Barnes & Noble, Staples, Instagram, TikTok, and YouTube in 2020, just to name a few. This bill puts several guardrails into place for consumers to better understand what data companies have about them and to give them some control of that data. As technology progresses and big data is readily available, their data is being used for targeted advertising for products and services. I had a story after COVID. I had went and got my COVID test, and you go to LabCorp to get your test. And to get my results, I had to log on to the LabCorp website. And through that process, I had to verify who I was. And some of the security questions it asked me, which I'll go over. It was 4 questions. One of them was like, what county, what month, what month of the year is Corrine's birthday in? Who's my mother? So it gave me options, and I was like, all right, I probably filled out a form. They have that information. The second one was, which cars do you own? Have you ever owned out of this list? Which none of them were the ones I owned. So I was like, oh, okay, that was just a guess. Well, the fourth question was, what is the county of residence for this address, which was a rental property that me and my wife owned, and it wanted to know what county it was in. And I was just like, what the creep factor of the information that these people bought. And like I said, my wife does privacy. I called her, I was like, why would they have that information about me? She's like, that's public information. People buy and sell that stuff left and right, which whole other discussion about the access to that public information and another bill. Maybe when I run for Congress, I'll run on that. But so, that was another thing for me to enforce, but, it was predicted in 2020, 1.7 megabytes of data is generated every second for every person on the planet. For a frame of reference, 1 megabyte is equivalent to 2 reams of, or 1,000 sheets of paper. So 1.7 megabytes is close to 2,000 sheets of paper that's being collected on you. I heard discussions earlier about, this data is being banked because they may find some future use for it. We put some data minimization in our bill. The arguments they have about the unlocking of data, maybe they just shouldn't keep it and they wouldn't have to worry about getting this stuff. So, this bill was a huge lift for us, and I was very appreciative of the process and my colleagues for doing it. It's opened up a lot more discussions for me. When we first planned this bill, we were thinking about including biometrics and a lot of other stuff, and just doing research on other bills, it's just too big of a monolith of policy to carry in one bill. And if you ever deal with legislation and stuff, it's hard to pass gigantic sweeping bills. It's the old adage of how to eat an elephant. It's one bite at a time. And if you look at policy getting passed, it's usually one piece because the big bills are so complicated. And this bill is still complicated. I didn't get everything I wanted in this bill. And probably neither did the AG. He came in and tried to amend it and do a lot of stuff. And I was like, this bill won't pass the way it was. They wanted to get more stuff into children. We had negotiated a lot of that away. But, it was an honor to be a part of some policy that will give Coloradoans rights that not a lot of other people in this country or the world have. It's not enough. It's a lot of work that I'll be digging into more in the future years, whether it's AI discussions today or biometrics. That this bill was so hard on me, and I married this bill so much that I've kind of have some PTSD about doing another policy bill. It's a lot of lift. It's like I said, there's a lot of people passionate about it, but it's not the people that are paying thousands and thousands of dollars of people in that building to tell other people this is just going to kill. Every bill is going to kill the industry as we know it. Every policy is going to hurt everything, and we constantly find it doesn't. But and to many of the statements here, not all actors are bad actors. There's companies out there that try to do the right thing. They have a responsibility to make some money. Some of the pride I have about this bill is it's the first one with the global privacy switch. No other state had put that in. We are the only state in the country that includes nonprofits. We'll see where that goes. It's undiscovered country for all of us. I'm nervous, but we're an incubator of tests. So if I have to change it, I'll change it. But right now, some of the digging I did and some of the research I did, nonprofits are a big use for people to hide ways of getting privacy, and that's how they fund. I had a lot of people chasing me about it with some of the news articles and the web people, and I did an article for, can't remember if it was the markup and stuff, but they did an article on nonprofits and why I did it. And for me, it was always like, I don't understand why not. But they had some web tools that they would track websites for a lot of these nonprofits and how much cookies and tracking and where they went that was on their websites. And as people were emailing me about them, they had no idea that their websites were tracking that much information. So they always like, well, I was like, why are you doing this to us? And I was like, I just, I don't know if we cap this at 100,000 records or higher with that much, not to stifle small business and innovation. We put exclusions for the health and safety and science stuff, trying to be smart about it. But, at some point or another, this will catch up. The tech industry, and now I think more as this policy is changing, we're seeing more information with the tech and the cybersecurity people getting involved in privacy stuff. It's becoming more and more, as I see policies. I ran a bill that you have to accept cash. If you guys go around, nobody's taking cash anymore, and credit cards are getting processed, just more information. They're tracking about what you buy and sell and what you do, or smart refrigerators that know when you open the door, when you get home, or laundry machines that know when you're doing the laundry, if you're doing them in the middle of the night or the middle of the day, or when you're home and when you're not, which just gets, I stayed up for a while when you think about that. So I have a little bit, I don't have a tin cap on, but I do think about all the things that get caught up with all the things you turn on. And the biggest argument I had when I ran this bill was probably the fight between now Meta and Apple, which was the right to track app that was put in. And it was probably one of the biggest sales that I had with my colleagues on this bill, and the data that I could provide was that when you were being asked if you would allow apps to track you outside of their application, it was about 4 to 6% of people were allowing it. And to me, that's why the industry doesn't want this policy, right? And even with the global privacy control, which I think they can make, they're like, it's untested data, it's untested thing, we don't think we could do it. I'm like, if it made you money, you could probably make it work. So there's a lot of people, mixed bags. I think I collaborated most on this bill with Microsoft, who I got a lot of grief for working with them because they're the big behemoth on the corner, because they're a gateway to a lot of data. But at the end of the day, the enemy of my enemy is my friend. And while I may not disagree with everything they all do, sometimes you have to pick your battles and who you work with to do this stuff. So the journey's been great. I've met a lot of great people in this process. I'm excited to have people that are probably as passionate about this as I am, that I had never known. I've got to speak at multiple events. Being at this is like, I'm kind of like a king of the geeks, I guess, on privacy law in the country, because there's so few of us, and it's not exciting, but I have that going for me. And I've met so many great people that want to work on this policy going forward. And, as we get more and more reliant on the technology we have, which, I had the GPS to get here. I understand when I'm giving up what I'm giving the things, but most people don't. When I would talk to people when I was running this bill, the older people have no idea how much privacy they don't have, and the younger people just assume they have no privacy already. So it's such a nuanced conversation, and I would bring it up with the young kids. It's like, what are you going to do someday when you're older and you're applying for insurance or life insurance or healthcare? And it's like, well, we noticed that you tend to go to fast foods an awful lot and eat a lot of cheeseburgers or greasy, bad processed stuff. That's going to affect your premium. And geek out or not, that's the kind of stuff that will eventually be available for people. So I just being here for a consumer, for me, in this bill that we ran and doing interviews and other states that are looking at it, the only advocacy I do for them is to push the envelope farther than what I did. I know the federal government has been working on a policy, whether it'll pass or not. I'm not sure how I feel about their preemption wording on it, but they need to do it. I'm working with some other senators. Connecticut passed a bill very similar to ours a year ago, and now we're starting to think of ways, because the fight with data privacy is that it's so hodgepodge across the state, businesses and industries comply with multiple states' policies. So now we're going to look at a process of maybe getting multiple states together to look at some uniformity, which hopefully will be an argument why the business communities can't support a policy that we're trying to streamline it for everybody. There will always be nuances. based on states, but at least with uniformity of language definitions and processes, it'll be good. I don't know if there's any questions or a pause and any broad questions anybody wants to get or any gossip of the legislative process, but I'm
Oh my
happy
gosh,
to take some.
so much. I'm gonna start with this. So first of all, this is already fascinating. I think when I teach about the various privacy regimes, I typically characterize the Washington privacy bill as the one that wasn't passed as the Microsoft bill, right? Because that was sort of how it fell apart in Washington state, was that Microsoft, effectively helped draft it, and NGOs in Washington state were not very happy about this. And as somebody who studies the GDPR, was tracking the CCPA, we are among privacy geeks here, by the way. It's just like it's happening. It was fascinating to me to look at the Washington bill and say, this is the only thing on offer right now that actually tries to track the GDPR. And the political economy of it totally makes sense, right? Like, Microsoft has to comply with this thing because they're a big global company. They would love for some state, Senate to basically enact it to impose the same costs on their competitors. So like, yeah, the enemy of my enemy is my friend, right? So I've seen that be picked up, and it's really interesting to hear you talk about that and acknowledge that that's deliberate, right? It's not necessarily that Microsoft is showing up and saying, hey, this is the version that should happen. It's like, this is a version that actually is like, the backbone is pretty okay. And I'd love to hear a little bit about the inside baseball process of taking that backbone and saying, what can we do with it? Like, what can I put in there that's going to be more than this? What can I put in there that's sort of got the initial buy-in, but I can kind of take it to a place that's definitely not what showed up on the table initially?
That's an interesting thing, because like I said, working with the tech nets and the larger tech groups that Microsoft was a part of, but you talk to them, there's a lot of anger and hate amongst them because of this. And for them, Microsoft is the big giant on the table, right? They have one of the biggest operating systems. They will have a global privacy switch. They will have the ability to track what they get because everybody gets their data on their platform. The carriers, the CenturyLinks, the Rise, they're the gateways to everything. And they get even more data than the provider, depending on what they use, if it's a phone or your internet or anything else. They were pretty collaborative on most of the stuff. They were a very useful resource in the technological wording stuff that you get into, because if you, and you guys have read these bills, me, who had somebody as a resource to learn this policy stuff and to talk about it, as a legislator, a lobbyist, or anybody that reads this bill has no idea what this bill says, what's good or bad. Interesting thing I was trying to put in a good, strong definition of biometric data in the bill, and I put a very strong version, tried to get it in the House, that included gait and a lot of stuff, because they wanted to exclude facial profiling, which was my fight with Facebook. And I was like, this was at the time when Facebook would tag you, and they got it taken out. But because I had people arguing that it was going to create biases and all the other stuff, and I was like, that's not what this policy does. And but because they don't understand the nuances of the policy, it was hard to get through unless there was a lot of trust. So most of the people were pretty collaborative. Microsoft was good, and the tech companies were pretty good too. The policy was very broad when we first introduced it, and we went all in with everything as hard as we could go with it. And
what was the initial private right of action, just out of curiosity? Like,
I never did a private right of action because I would have never gotten that. The reason I did not do a private right of action, as much as I'm a pretty big consumer advocate, is you can't get private right of action bills probably through just my caucus, let alone Republicans. We see a lot of that stuff, whether it's other types of negotiations or I can't think of the word now, but we've had big fights over right of action. So I knew I could never get that in my policy. So that was never an idea for me to do. It was my concession for me personally to have a bipartisan bill.
Yep. Because
when you have a majority of 17 or 18 in the Senate, 2-3 people, if one side completely hates it, 2-3 people can completely gut a bill. Manchin, Sinema, Congress. So, my strategy was to pass a bill bipartisanly, because for me, if we talk about Washington's bill always died because the AG and them wanted a private right of action and the sponsor didn't. So weird argument. And I told him multiple times, like, dude, if you pass that bill with that, you will be the trendsetter across the country. And it's a nuanced argument because I talked to somebody in Florida that was running this bill too, as well, who tried to put a private right of action. And for me, being in Colorado, private right of actions, it's lawyer, there's too many lawyers. I think it creates jobs for everybody, but it is what it is. But in the South, Republicans are trial lawyers, and they were more up for it than I would get it through here. And here, trial lawyer is an evil thing, and they're here to ruin industry and just raise costs. And it's an interesting argument. But then you go to the South, and they're like, oh no, we love taking on big business, and who they, can't remember the name of the congressman that's in the Senate that's a trial lawyer that's a Republican. Lindsey Graham, big trial lawyer advocate. You wouldn't know it, but he is a champion for trial lawyers in Congress. So live and learn. But so that part of the bill I could never do. So, and the opt-in, we tried, but we knew we wouldn't get it through our caucus. And by the time we had spent a year, because we were going to drop it with that the first year, if we'd have worked on it in the summer with that in the bill, we would have never, they would have lobbied it before we got to the floor. So we took it out in the interim to go back to what we had, but that it was, I think Senator Carlisle is the grandfather of all reasonable privacy bill. California's has gotten much better. At the time when we did it, it was a little note. I think when I talk to other people in states when they're looking at privacy, if you really want a good privacy bill, you put it on the ballot. Just like California did. You will get opt-in, you will get everything, because there's nobody that doesn't. Privacy polls at like 80% positive. It's just who's got the money to spend to get it on a ballot.
Yeah, there's still sort of a pet project of mine would be to try to revive conversations about, state constitutional amendments around data privacy too.
That would be fun. It would just be, then you need 55%.
Yeah.
You could get it. You could get it on this bill. Let me know
Totally.
when that guy, you can meet that person. I'm happy to help you.
That's awesome. So I also want to go back to, I'm not even at my questions yet. I want to go back to something you said about having some regrets. What were the regrets of these, compromises that you made that you think you actually probably didn't have to?
Not being a lawyer, one of the first concessions I made was my tweaking of the wording, any entity connected to the Graham Leach Wiley Act. I didn't, you guys all, words mean something in contracts and legislation. It was one of my first big ones, and I accepted the wording. And I didn't find out until somebody did an article on the bill that I completely gutted the financial sector.
Got it.
And I yelled at a lot of people after that. But I also had to own the fact that I made that mistake. So that was one of my big regrets I did on it. Probably some of the other ones is that I didn't push to exclude. This bill had government covered in it until the House.
Huh.
I had government in this bill until the House. I got yelled at by everybody. It's like, how could you? I was like, this has been in since it introduced. You didn't pay attention. And probably excluding CU and CSU. Again, the lobby, but yes.
Yeah, that's also fascinating about the university lobby.
I should have sent you in. It's like, no, we can do this.
Yes, next time. Yeah, so then the returning to my conference relevant questions, I think it's not necessarily intuitive for most people that transparency is a core principle of data protection. And so when you were talking to your colleagues, or you're talking to constituents, and they're thinking that you're writing a bill that's a privacy bill that will let them fully control information. I heard control in your preamble, and control is a big part of this. But how did you characterize the transparency provisions? Like, how did you explain to people that that's actually core to or connected to data privacy?
I mean, you got the 5 things. You have the right to delete, right to correct, right to opt out of sale, right to collect what they sell on you. I had it up on my phone. I don't remember the 5th one off the top of my head, unless you do.
What was it? Correct? Yeah. I think
Right
you
to
said
correct, right to sale, right to opt out, right to delete.
Yeah.
And there was one other one.
Was access.
Right to access.
Yeah, that's the big one.
Yeah, which an interesting note, which gets into some ethics questions that popped up earlier. There were people that tried to amend the bill to allow, I think our bill allows you to pull your personal records like once or twice a year. There were people that wanted unlimited, which would have been a humongous fight with the tech industry if they had unlimited. But there's companies out there that will pay you to sell them your data. And there's discussions federally, I've heard it from Congress people, stuff that, You get it, who's, the argument is, at the end of the day, whose data is this, and should you be able to sell it? There's apps, there's a Colorado-based company that pays to track what you buy and sell and shop on. And that was, somebody was trying to get that in the bill. And we can get into the ethical discussions of who that's gonna target, who's gonna get taken advantage of that. That's probably a class for you guys to have, or an
Yeah,
ethical discussion.
in our classes, we talk, my class, we talk about, the benefits and costs of framing this as being property. And that's a great example of, a potential way to distinguish between privacy and property. But yeah, so when you're talking to constituents and they're saying, privacy, 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 what do you say about the access parts of this?
Well, I tell them, well, I haven't seen it yet, so I
Yeah.
don't know what it's gonna be like. I barely started looking into what California is doing, is they're starting to do it. I'm excited to see what it's gonna do the first time, because I'm really excited to see what I'm gonna ask them to, what I'm gonna ask who to
yourself.
provide to me.
Yeah.
I try to tell them, the biggest enhancement for me for this bill, because it is complicated and it's so new, how many people in California are probably pulling their records and stuff. I'm sure there's people doing it for research and articles and stuff. The biggest thing I think that this bill does that the other states is that switch, that global privacy control. It's too complicated for anybody to know and go in and you go read your click boxes, track cookies, this, that, this. If you just had a button said, I don't want my stuff sold, that's the most consumer friendly tool that we can provide.
Yeah, so this is fascinating because, you have GDPR. GDPR has various ways in which you can block the movement of data. And almost all of it, I think Jeff was talking about this earlier, is, a standard that then gets interpreted through guidance that then gets implemented in companies. And I remember first seeing the CCPA and its sort of detailed description of like, you're gonna have a button, it's gonna say, do not sell my data. It's gonna appear on the front page of your website. And I was like, oh, well, this is interesting. That's not the same. So this switch, right, is similar. And it gets to the theme of transparency. It's about, transparency is not just, let me disclose all your info. Transparency is, let me make this really usable for you, so that the underlying right we're trying to get at is the choice, right? To not give your data.
Right.
But the transparency can be designed in a way that frustrates that choice or that really like enables that choice.
So it's interesting. So as somebody who got into this and I set all my cookies, turn off all my tracking apps on my phone, and I can't log into my Gmail or my Amazon anymore because it doesn't, I have to turn on my cookies, which I was like, that didn't used to be a thing, but somehow that's very needed for you to log in now. And obviously, which is a new thing for me for the GDPR, having to opt in and everything every time you click on something, I also switched to using the DuckDuckGo app on my phone, which it works fine. I've gotten used to it, but it was really nice when my password would insert automatically and I could just do it. Well, now I have to go pull up my password and I have to put it in. And I was like, see, that's the kind of, I don't know as a society in the United States that we're ready for that.
Yeah.
And it would be very frustrating. And sometimes I get frustrated that I put myself through that, but I'm the privacy geek. I have a Facebook account and a Twitter account. I don't post, my staff does, because I'm the privacy guy. I just don't like, I look at it and read it, but I don't post just because I know what they're doing. And it's interesting, we'll see how Elon Musk and them deal with the new thing. Now they're gonna sell it. They're literally saying that they're gonna use it for advertising. So
Yeah.
it'll be interesting to see the direction that goes. It'll be interesting to see how with reproductive health and that stuff now with tracking and stuff next year. I've met with a lot of these organizations. I was like, I don't know how you guys are gonna function in the United States, because some states are gonna tell you to block that data and some states are gonna come after you to share that data. Because we want to know who's going to abortion clinics. We want to know who's going, the phone companies, the Ubers, the Lyfts. What are you guys going to do? I think Uber, Lyft, or somebody are getting harassed in Texas already. I think for some of this stuff, it's a new spin on privacy. Everybody's like excited to have it now. These guys either believe in privacy, but it's going to help us go after people and do headhunting. So now we're going to do it. So it will be an interesting couple years to see how some of this stuff plays out nationally. There's a lot of great apps to track this stuff. I think we've got 27, 28 states have run this bill, tried to run an iteration of this bill, and none of them have passed it. So being the third is an honor. We could have been the second had it not been COVID, but I take that on.
I love you. You're always going to hold that.
Well,
Yeah, so follow up to that, and then my final question, and then I'll open up to everybody here. So my follow-up to that is, you talked about how this was a bipartisan experience and that it was almost surprising to see counterparts across the political aisle. Do you think that sort of the characterization of data privacy in relation to reproductive rights is changing that coalition in any meaningful ways, or is there still really a bipartisan appetite for generic data privacy law?
I think generic consumer data privacy law is probably pretty broadly supported. You get into the nuance of this, and so there's looks at Colorado, and I was having a conversation earlier, there's looks at doing protection, data privacy and stuff for reproductive health in the next year. And I've talked to them, and I'm happy to help. This is more complicated than, oh no, it's not. And I was like, they're like, no, I just don't think people should be able to get access to that data. And I was like, so what about murderers or other crimes or things or terrorism? Like, that's all protected too. And it's a very nuanced conversation when you get into legal stuff. And I think partisan wise, when it's legal or their sole beliefs of protecting a life, that's not going to be a concession because, it's investigated. The federal government probably has more access than I'm comfortable with, but it's about some safety, and I have to be able to be okay with that balancing act. And I just hope I elect people that are smart and make sure they're protecting it and doing the right things with it. So I think there's a lot of good actors. The hard part with the small ones is they want to be the big ones, and they're going to use every cut to get to be a big guy. And then I think the big ones generally try to do the right thing, but it is still something that could be monetized.
So then my final question before I open up to you all is about the privacy impact assessment portion of the law. So again, this is a part that I was particularly excited about. It's not, not initially part of the California regime. It's sort of the compliance, the boring compliance side of privacy law that actually potentially has really significant impacts in terms of how companies end up, processing and mitigating the harms that arise from processing your data. But one feature of the Colorado Privacy Act is that it specifically exempts privacy impact assessments from state open records laws, which means that it's envisioned as being a document that regulators can access, but not the public or third parties. And I know there's some back and forth over the regs and how much you can get stakeholder involvement in that. But I was wondering if you could talk about sort of that limit on transparency, right? Like what's the reasoning behind we want these to exist, we want the information to be produced, and we don't want it to be released to the public?
Well, and at the end of the day, which, you get into AI, some of the directions need to be some type of impact assessment of what the decision-making process is, similar to this with the data collection. And, the tool is designed to help them assess their collection and to make sure there's a process that they're thinking through what it's being utilized and not being protected. I think the unintended consequences if you made it too openly public is if you're developing a new technology, a new platform, you could be doing a really good, thorough assessment. And are you giving up proprietary information? Somebody pulls it and a competitor, somebody's like, oh, well, hey, now we know how he's doing everything and we can go out and do it. So there has to be some type of guardrail. And maybe it's something we look at later, another date, but I think there has to be some protections for people that are trying to do the right thing and trying to develop a technology and innovation that they have the protections to go forward. So,
yeah, so
which are some of the discussions you had today with the transparency.
Yeah, so maybe not a transparency trade-off, but a transparency paradox. Questions from the audience? So many. All right, I've got Sam and then, and then Nate.
Hi, thank you for speaking with us. Very interesting to hear kind of the behind the scenes. So my question is about sort of at the beginning, you were talking about how the Apple Ask app not to track notification is really successful because it kind of asks for what you don't want to happen instead of making you kind of consent to something you don't really understand.
Which, or no.
Yeah, and so I got that from Meg. I'm in Professor Kaminski's class, and Meg gave us a great guest speaker presentation about why consent is basically totally flawed. But I was wondering, since like the opt-in model probably would have addressed those types of concerns, but given that that was something you had to concede, was there any other kind of like avenues you tried to explore to accomplish something similar? And then sort of a part 2 question is, how are you able to get the privacy or the global switch passed and not the opt-in?
Repeat the last part again.
How are you able to get the global privacy switch passed, but not the opt-in?
God. You could read a lot of articles around the country that for people who chase or read privacy stuff. Probably for the corporate industry, they're probably two biggest things to fight nationally on all privacy policy is opt-in and right of action. And honestly, through this bill, and I'll tell you an interesting story on one of my stakeholder meetings, through this bill, having the global privacy switch was always one of the hard lines that I do. You know, like I said, we did a lot of things in the bill and we gave and gave and gave, but it always gets to a point like we're not giving on a few things at the end. And we got to that at the end. A lot of the biggest fight at the end was Facebook, but I had a stakeholder meeting and most of the meetings are productive, and it got to the point where I'm like, just send them in writing because you have so many different interests and so different processes that everybody was speaking over each other. So we got to a point where they'd write all their needs and we'd go through individually, agree, disagree, here's why, disagree. One of the last meetings we got to, I sat on with TechNet, another tech organization, some of the chambers, who just sat there for 30 minutes telling me how the global privacy switch was an unproven technology and it just can't be done. And, you know, other states have tried it. And it's just, we've done this before. We've tried this in the past. It's just not plausible. And I finally ended the call with the only plausible policy that actually does work is opt-in. So if you guys want to go with something that works, we could go with opt-in. Ended the call abruptly. They were all freaking out that I was upset. And then lobbyist had to yell at them and say, look, you can't beat the dead horse. He's not going to move on that bill. So unless you want to address everything else, you're not. And most of the coalition and most of the legislatures, as we had conversations, understood that who can be against something that says, do not sell my stuff. It's the most simplest way to do it. So that was the best concession I could do to opt in. And it seems similar. It's so much easier than clicking every time you go on a website. I already hate having to accept cookies if I pull up a link on something, but next
Nick.
question.
Oh, wait, one more.
Here
Microphone.
it comes.
Well, thank you very much, Senator. This has been fascinating. I'm curious, I know the process isn't done, but what do you think the costs and benefits are of this Attorney General notice and comment period?
Having AG oversight is probably one of the biggest pieces in doing this kind of legislation, unless you're going to do a private right of action, which is the huger lift to do. California's private right of action is very limited to a certain piece. The AG had to buy it. Other states, the AGs don't want to get involved. AG Weiser had worked on this in the Obama administration, was very knowledgeable, very engaged in wanting to do this when we first tried to run it the first year. So he's always been an advocate and a champion, and his team was very resourceful. And he came to me and it's like, I want rulemaking. And as somebody like dark pattern discussions, dark patterns wasn't even a thing when I first ran this bill 2 years ago. It came in through an amendment through AG Weiser's office as we were running the bill. Could have got more detailed, but the best thought was this technology changes so fast. I think rulemaking is the best process. I mean, I was talking about cookies and running a right to track bill, and I think after my bill passed, cookies are becoming a whole new technology now. So, you know, we can't legislate as fast as technology changes. So having rulemaking and hopefully always a advocate in the AG's office for consumer rights is the best avenue to to keep up with the tech changes as they come. I think that was the best route we went, and I'm very lucky to have an AG who has buy-in on this process. He had a great conference on this. He brought in some people from Washington. I'm very blessed that his office is involved. We're lucky in Colorado to have somebody that's that passionate about consumer protections for this stuff. So, yeah.
Yeah, I'll also add to that, you know, there are some political elements of this too, right? Like where you might not be able to get consensus on a definition in the legislative process. If you have a broad term and you're delegating it to the AG's office, that might be a different process for getting a similar definition. Just to pose a hypothetical. Any other questions? All right, we have one here and Gela.
Quick story while you're walking the microphone. Another regret I had, which I think in the draft we had coming out of the Senate that we had to tweak out a little bit. I had taken out, and I don't know if, I assume you all know privacy, I had taken out the definition of pseudonymous data because it's just a GDPR term, it's just de-identified data. The technology is out there to re-identify this data, And you would have thought I ended the world as we know it with this policy when I took that out. And I'm like, you already have de-identified. You don't need this definition. You're like, you don't understand. They practically admitted that they use this information for that reason, which I need to follow up with the AG to make sure that's addressed in rulemaking. So
Second bite of the apple.
Yeah, thank you so much for talking to us today. Could you expand on what the internal debate looked like to include nonprofits and kind of where you see that going? I know that Colorado is unique in the fact that it did not exclude nonprofits and where you think that that direction might head in.
interestingly enough, I don't know if people missed nonprofits in Colorado. I'd always had nonprofits. For me personally, I don't understand anybody that has that amount of data, why they don't have a responsibility for protection and access. Maybe we have a discussion about the technology of releasing and not selling. I'm sure they sell, and they may not even know they sell, but some of them are just as gigantic as any other corporation. And I had a couple of people come to me, I think it was some insurance fraud nonprofits and some college, school, elementary school nonprofits that collect data that were, you can't do this, no other state has nonprofits, you just need to exclude us. And never once did they come back to me with a solution to fix their concerns. It was just stop doing it. And I, because they're nonprofits, would go look up every one of their 990s and see that they were 15, 20, $35 million in revenue every year and said, you have the ability to protect this data. So I never budged, it never blew up for me. I guess I just got lucky. We'll see if I'm lucky in a few years. I was like, oh my God, what did I do? Because we'll see. But if we're not doing it and finding out that things are happening, then how will anybody know? I think Washington, if I can find the article, I'll forward them to show it to you, but there was an article and they talked, every other legislator who ran this policy wished they could have had nonprofits. It's just not a fight they were willing to take on. I got lucky. Oh, we got lucky.
Thanks. My question is a little bit about, so you mentioned the opt-in and the private right of action were excluded so that you could pass the bill. What were some of the inclusions that you had to, I guess, insert that you didn't want? And so the second question, this is a little bit trivial, but why the 100K limit? How did you arrive at that number?
Honestly, 100K was the same. I mean, California has a limit too. It's just a little differently worded. It was the wording that Washington had. We're a similar size state. It was already kind of vetted type policy. The arguments, if somebody has that much record, you're going to exclude the smaller companies that are going to get caught up in this, that don't have the resources to do this work. So it was, I assume at some point in our life, as this policy gets more, the technology and stuff will come out as people start developing things for tracking and selling and collecting data, will get more beneficial for smaller ones. But to stifle a startup with this kind of cumbersome policy is just not feasible to do. Private right of action for me, I think, is the most enforceable piece of legislation, because the AGs in them are probably going to go after the larger, bigger actors because they have to invest a lot to research it. But I would rather have something rather than nothing on the books.
Yeah, I think too, there's the element of, you mentioned earlier the possibility of coordination between different states to try to harmonize between states, maybe as sort of a preemptive defense against the argument that we need federal law that's preempting.
Yeah.
And so those numbers being the same across different laws, I think also may be part of that effort. Any other questions from the audience? Oh, you had the second question.
Yeah, go ahead. We have 10 minutes.
Inclusion is the first part.
Oh, okay.
About like what?
Well, the GDPR exclusion wording was not, I wasn't happy with. My colleague did some exclusions for airlines and FAAs, the FAA wording, which I wasn't happy with, but United is a very big hub here, and he did it while I was with COVID in the legislature. So, so he had to carry some of the bill, and I was like in the committee, and I was like, why did you do this? Why would, he's like, we'll fix it later. I was like, never fix it later. But when you work with colleagues and you work with other people on the bill, you can't, I have to collaborate. I can't get everything I want. And if it wouldn't have been him doing it, they would have lobbied a lot of other people to get it in the bill. And sometimes you have to pick and choose your battles. Every state has different nuances. United is a big hub here, and they had a statement and an exclusion from the court in California that got applied there too. And it was like, they'll just take it to court here. Was the fight worth doing it? I still read the privacy statements when I go to the airport for United, and I'm still concerned that they're doing a lot of stuff. But it was one of those things that they had case law. So that was one of I feel bad about. And pseudonymous data. I couldn't keep that out.
Yeah. Yeah, was the United argument was a preemption argument?
It was excluding them from privacy rules because they had a
They're
court
covered by
case
the
in
FAA.
California that they went to court for. California's one that said it doesn't apply to FAA,
Yeah,
federal regulation. So
yeah, that's interesting. I see Meg.
Thank you so much for coming. On our last panel, we talked about transparency and the historical record. And the kind of historical work that I do is everything that you are divulging to us now. It's so hard to get this type of insight when we try to tell stories about how we've come to regulate computers the way that we have. So this is so valuable. It's also very entertaining. And so I really appreciate you being here.
yeah, it was a journey. I mean, I did marry this bill, and they tell you as a legislator never to marry one, and I did marry this bill because I was so passionate to get over the thing. And like I said, it's kind of cool. I'm excited to see how it turns out in a year. I'm, like I said, honored to be a part of a policy that's transformative for people across the country and in the state, and just to be part of something that's setting the trends for what could possibly be a federal law, you know.
Yes, congratulations on your union.
I owe it all to my wife.
Yeah. I have a question about the global privacy switch that you are enthusiastic about. So I'm curious about how it's being designed, just how we had do not track. We've had attempts at browser level controls, like do not track, and I think that California calls theirs global privacy.
Ours is a global privacy control as well.
It's a global. So are you continuing to pay attention to how that gets actually implemented on a technical
I haven't
level?
been digging in as much on the privacy stuff. I need to start digging back into the rulemaking. I hadn't been, it's an election year and I'm up, so I haven't dug in. And like I
Yeah.
said, I occasionally go look at the privacy websites and read stuff on it and Google the newsletters every once in a while. I just haven't done it as much lately because I need to look at more policy. Last year was just, I didn't dig into it as much. And next year, so our bill, we put an extra year extension on it because of the arguments I got. And it was a negotiation with the industry when I was doing it. They're like, this is not proven. I was like, well, then we'll make the rules go into effect in July of next year. But we'll do another year for the privacy control to give the AG to come up with rulemaking, who's working with other states to collaborate rulemaking. But there's a lot of examples of people out there that one of the guys that works, Ashton in California, is a humongous advocate for the global privacy control. So I'm confident it could be done. I gave extra time because I conceded because I was like, look, I'll give you another year. If it's not proven, if it's not going to happen, we can always change the law. So that was the avenue, but I didn't give up. Everybody's goes into effect, I think, January of this year, a lot of the other states. I conceded to the retail council because look, it's the holiday season. We really aren't ready to gear up for this. So it was like, it was a reasonable ask. I was like, okay, 6-7 months. We're already later in the session anyway from when the other bills passed. It's like, I don't care. Most of the states are going to conform to the tightest legislation and make it go across the country anyway. So the timing wasn't bad. As you all see the accept cookies thing, and that's not because they're protecting our data. It's because they're doing, it took me a while to stop going through that saying they're not doing this for me. It's
Yeah.
just on the website.
Yeah, I should also just highlight Meg is the authority on cookies in the audience. She's written a cookies book.
I was going to run a right to track book, a right to track bill. Should have called you, and then it's all changed. It's like, yeah, cookies.
That is the trend, though, that you're seeing across states, is they're latching on to this global privacy control.
Well, California did it before we did, but theirs is only on part. Connecticut did include it. They're the last state that's passed it. Virginia did not have it. Utah did not have it. Some of the other states' bills I snicker at. I mean, I was not happy during the process of my bill. It was always, we want you to be Virginia. We want you to be Virginia. We want you to be Virginia. And I read Virginia as like, no, I'm not Virginia. This is Colorado. When I passed the bill, I apologize profusely because how hard it is to get this legislation done. And I don't care what you the bill, whether or not, it is not easy to get done alone. And that bill was still the second bill after California get passed. So for me, pushing the envelope a little farther, Connecticut has a little bit more strength than I do. Some of the other states might have went backwards. There's a big hodgepodge of people like if we weaken this bill and make it stronger here, when we go federally, they're gonna have all kinds of things to choose from. I hope every person that runs this policy, my only goal for them is make it better than mine. That's all I can ask.
Do you think there's any appetite for, I know California did this through the ballot initiative process, but is there any appetite for going back to the CPA a couple years later to make it, to regulate up?
Well, it would scare the crap out of everybody,
Yeah.
including me, because when you open Pandora's box, what can get in there?
Yeah.
People are like, are you gonna make a change? And like I said, the nonprofit would love me to exclude them.
Right.
Some of the other ones are looking for ways to run a bill. And I said, if you don't have buy-in from us and the AG, it's gonna be harder, but whatever, everybody gets to try to run their bills. I haven't seen a reason, or the AG has not come back to me to say we need to do physical changes to the policy to need me to go in and do it. I'd like to start looking at AI, biometrics. We start talking about meta and virtual worlds, and now have your eyeballs getting scanned and you're looking at stuff, and now they see how your eyes open and dilate when you're looking at things who knows what's going to come out of that. And those are the things we need to start getting ahead of. It's too late for data privacy for what we've done. It just got ahead of us. We got to start thinking ahead for more rules for them. And I think these assessments and stuff, it puts accountabilities on them to think through, because they're excited to do any technology to do it, but I don't think they're not as responsible to think through the unintended consequences of what they're doing. And that's where we need to step in and say, I don't think we need to do super regulate. You need to write down something of what you're doing and why, so at least you have something to refer to.
Yeah, I mean, one of the things that has been coming up in conversations around AI policy recently is just the notion of AI snake oil, right? That there's not a whole lot out there to say, you're in trouble if you promote an AI system as being able to do something, and it turns out it can't, right? It turns out it's bad, it doesn't function. So very excited to continue these conversations with you. Thank you so much for joining us. You can all join me in thanking Senator Rodriguez.